In this video, I'm going to explain exactly how I got 88% in business law and practice on the LPC. So the first thing that I want to talk to you about is structure. Structure is so important. You want to make the examiner's life really, really easy, and the easiest way to do that is by putting headings and making it all just very easily and clearly structured, so it's as easy as possible for the examiner to allocate you marks. Then set out the law and then apply the facts, and then conclude so it's really obvious what conclusion you have reached at the end of it, and that is the winning structure for a distinction on the LPC. So I'll show you how this works in practice from a practice question that I answered as one of my revision tasks, and this is about partnership and whether an outgoing partner would remain liable for debts incurred before he left the partnership. And what I've done firstly is set out whether there was a partnership, because on the facts there was no partnership agreement. So whilst there was no partnership agreement, the terms of the partnership would be implied by the Partnerships Act 1890. So there's the law and there's the fact applied together. And then I've gone on in the next sentence to say that partners are jointly liable for debts of the partnership, and that's from section 9 of the Partnerships Act. And then I've gone on to apply the law to the facts, and I've said that this means that Charles and Bob are both liable for the outstanding debt owed to Barrett's, which was part of the scenario. So now I've established that there was a partnership and the terms will be implied, and that because there's a partnership, both of the partners, Charles and Bob, would be liable for outstanding debt. Now I can talk about what happens now that Bob has left the partnership. So I've set out the law here. Outgoing partners remain liable for debts incurred before retirement, and that's from section 17(2) of the Partnerships Act 1890. And then I've gone on to apply the facts from the scenario given, and said that this means that as the debt was incurred in February 2020, the month prior to retirement, Bob would still be liable for the debt. I've then gone on to talk about sometimes that partners can discharge their liability for partnership debts through indemnity, but then gone on to say that on the facts here, only simple valuation of the partnership share took place and the debts of the partnership were not taken into consideration, so it seems unlikely that that would apply here. So then you can see that I've clearly concluded and provided an answer yes, just in case there was any doubt, that yes, he is jointly liable for the debt. So this next question relates to how a partner who leaves a firm before a debt is incurred might still be liable for that debt after he's left. So for example, if I was in a partnership and then I left on the 1st of January and then debts were incurred in June of this year, I could still be liable for those. And then so the questions asked essentially, how can we prevent that from happening? So as you can see, firstly I've set out how the law says that a partner who leaves a firm before a debt's incurred might still be liable, and that's through two ways: holding out under section 14 of the Partnerships Act, or failure to give appropriate notice of departure, and that's under section 36 of the Partnership Act. So then what I've gone on to do is apply the facts here. I would advise Bob to ensure that his request for all stationery to have his name removed has been complied with. So I can't remember what the scenario said, but I assume it would have said something like he's asked for his name to be removed from stationery. So then I piggybacked on that and said, okay, let's ensure that that request has been complied with. And then I've gone on to say he should also ensure that his name doesn't appear on headed paper and that no old headed paper is used, so he could arrange for it to be destroyed. Ensure that he's not referred to a partner already, and not act like he's a partner. So I've tried to use as many facts as I can from the scenario, but it seems like that there perhaps wasn't a lot to go with. So sometimes it won't be possible to apply everything to the facts. write down everything you know about how to avoid holding out and apply the facts as best as you can. So the other way that a partner can be liable for debts incurred after leaving the partnership is failing to give notice. So I've set out the law in green. Actual notice needs to be given under 36(1), and a notice in the Gazette needs to be provided under 36(2). And then again, I've applied the facts clearly there as much as I can in red. So I hope that's really clear about how you should set out the law and then apply the facts. Okay, let's move on to the board meeting decision process. So board meetings come up a lot. They're usually quite chunky questions in the exam where you can pick up a lot of marks. The first thing you'll notice is that I've put headings. So you can see under notice, I've underlined it, and then I've spoken about what the law is to call a notice for to call the board meeting. You need to give notice of the meeting to the directors under Model Article 9, and then the notice must be reasonable, and that's from Re Homer. And then the notice must include the proposed date and time of the meeting and the location, and the notice need not be in writing. I don't know if that's a separate authority. If it is, include it. I can't remember now. So after I've set out the law, I've then applied the facts and just said that any of them can call the meeting because they're all directors, and then just said what they need to do and said that there's no indication that a few hours to a few days notice wouldn't be unreasonable. So yeah, that's how I've applied the facts there. You could do it bit by bit, as in one piece of law, one fact, but I've just done it in chunks because I found it easier on this occasion. I don't think it matters exactly how you do it. And then you can see that I've moved on to quorum and underlined that. So for the board meeting to be quorate and be a valid meeting under Model Article 11(2), the quorum cannot be less than 2 directors present. I've highlighted that in green, and then we can see on the facts that there are 3 directors. So there's no indication that they wouldn't all attend, given that they're all in favour of the proposed resolutions. So really try to pick out the facts and apply it there. There's no indication that any of the directors have an interest in the proposed resolutions. So Model Article 14 wouldn't apply to the facts there. I've then done similar things for declaration, agenda and voting, and then set out the administration that is required afterwards. Okay, so the next thing that I want to talk to you about is the pre-reading that comes out. I think it's for all the core modules, don't quote me on that. I know we definitely got it for business, law and practice. So once you get the pre-reading, look at it, read through it, think, okay, what topic is this on? And then see if you can write out a template for the answer that is likely to, for the question that's likely to come up. That's exactly what I did. Every time we get pre-reading, I managed to predict 90% of what they're going to ask. And then I write out a really clear template, as you can see that I've done here, and try and set out the law and apply it to the facts as much as I can. And then I don't necessarily know exactly what the angle that the question will come from, but it will save you so much time in the actual exam, because all you'll have to do is copy it out, adjust a few things, and but you know, the majority of the answer will all be laid out for you. So as you can see here, we had a question about preference transactions. So I wrote out a huge template about who can challenge it. So the liquidator with consent from the court or administrator. And then once we got the actual question given to us in the exam, I would have then elaborated on that a bit and said, on the facts, this person can challenge it. You know, the liquidator in the scenario, and applied, you know, more detailed facts to the law. So look how much I've managed to write. I've got the law there. I've set out as much as I can in relation to the facts after setting out the law. If you're not doing an exercise like this, then I really think you're missing out on an opportunity to get ahead. because the exams are very time pressured. So try to predict as much as you can and write out as much as you can that you think will come up, because it's definitely how I manage to maximise points. And as you can see again, I've put lots of headings and underlined my headings just to make the structure really, really clear. Again, you can see how much I've managed to write. So hopefully I've helped you a little bit in relation to how to answer exam questions and how to apply the law to the facts. Please let me know if you've got any questions about anything that I've showed you today. But I thought I'd finish with a couple of extra points that really helped me. So the first thing again to remember is structure. The second thing that you should be doing is creating as many templates as you can to help you with speed in the exam and organisation. Have 2 folders. One folder with legacy notes in there and templates that you've created. That will be a thinner folder generally. And then have a second folder with your workshop tasks. If you're anything like me, I didn't really have to open that much. I relied on the legacy notes and templates, but I kept my workshop tasks and answers as a little bit of a safety blanket. Tab everything. Make sure that everything's tabbed because, like I said before, the exam is really time pressured. So if you can navigate to things very quickly, then that will help you so much in the exam. Make sure you practice the MCQs in advance. That's the multiple choice questions if you don't already know. Don't just do them once, do them as many times as you can. I can't remember how many times I did the business one practice ones, but for wills, I did 700 questions and I got like 91% in the exam. So do as many, I'm not saying do 700, but do as many as you can because they are tricky. Now go through all of the workshop tasks, practice them all as revision, do them at least 2 times as revision, and that's 2 times each, as revision. And then redo the specimen exam and the mock as many times as you can fit in before the exam. I think I did the specimen exam probably twice. The more you can do it, the better. It's just practice. It helps you to navigate around your notes. I think that's, it's an open book exam at the end of the day, so you don't need to memorize things, but you do need to almost be very familiar with it so that you know exactly where to find things in your folders and you know exactly what sort of thing you need to write. It's just a case of actually copying out the law and applying the facts. So yeah, I hope this video has been helpful. Please let me know in the comments if you've got any other questions. I'm going to do one of these for all of the core modules. So if you would like to see that, then please hit the like button so that I know that people actually want to see these types of videos, and also subscribe to make sure that you never miss a video from me, and I'll see you in the next one. Goodbye.